Folks, it's Steve Sanson and Jim Jonas for Veterans in Politics. Today, our guest is Marie Parladè, candidate for Clark County Family Court, Department A. But before we get to our guest, Jim, have any rants?
It's not necessarily a rant. Not trying to make you nervous before the interview starts, but Steve and I have been, Steve started it more than I have. Been involved with family court for a while. So I know you're running for family court Department A. And just so you know, before it starts, I have a motto that I have a problem with a lot of the family court judges and the family court, the way it operates in general. So I just want to make sure we kind of nip it in the bud, so to speak, and make sure you're completely qualified and understand the corruption that goes on in family court. So if you are elected to this seat, from day one, you understand your role and what to do. And so Steve and I don't have to regret or come back later and say, some of the, not use your name in vain, so to speak, but we've been involved with other family court candidates that are not now family court judges, and they seem like really good, competent people at the time. But then once they got elected, they weren't. So I just want to say that I just want to make sure that you understand the exact role of what a family court judge does, and then be able to explain exactly what makes you qualified for that seat.
Absolutely. Thank you.
Steve.
Hi, Ms. Parladè.
Hello, Mr. Sanson.
Could you tell us about yourself?
Absolutely. Would you like me to look to you or look at the audience?
Oh, look at us.
I will look at you. Okay. Sorry, I'm going to look at them though. All right. Well, my name, thank you for pronouncing my name correctly, Marie Parladè, with an accent over the E. We talked a little bit with conviction. Maybe I'll tell the viewers about that another time, but we'll keep that as an inside story for now. Okay. I thank you so much, Jim, for sharing with me. And, I hold everything that you said at face value, because the role of a judge is to be impartial, is to be independent, and is to uphold the integrity of the law and to apply the law to the facts, and not to let our personal bias, convictions, or predispositions get in the way of the strict application of law to the facts, with the end product always being to serve our families, those that come before the court. I was looking at the Nevada Constitution this morning, just, asking the Lord, just give me a primer and remind me, what's our North Star, right? The U.S. Constitution, the Nevada Constitution, and government is in place to protect and serve the people for their security, their benefit, and for their peace, and to uphold the laws. And it's a travesty when that doesn't happen. I can't speak for other people. I can't even condone anything, but I can just say that you have my commitment and you have my track record to establish that I have been a public servant for at least 10 years. I have represented the most vulnerable in our society. Those are the children. Over 20 years ago, it started at the University of San Diego. Grew up San Diego, born and raised in California. When I went to the University of San Diego, I come from a family of attorneys and politicians in the Philippines. I'm the first that's born here in the United States, the first that's licensed here from the Parladè lineage that is here. And so when I went to law school, I discovered child abuse and neglect. I kind of grew up in a semi-bubble. I wasn't as acclimated to the society, to the injustices of our society. And when I discovered child abuse and neglect, and I discovered that children were being abused and neglected in their homes, then ripped from their homes and placed into other homes where sometimes they were subjected to even more abuse and neglect, that broke my heart, that ripped my heart out. And from that day forward, I vowed that I would represent the best interests of these children. I did that as a law student. I did it so much that they kind of told me, you need to slow down because you exhausted all your hours as a children's attorney. You exhausted all your hours sitting in as a law clerk and doing all of the activities that would allow me to have exposure, whether it was in the court setting or in the setting of representing children. I did that so much that they recognized me as the outstanding child advocate for the University of San Diego, which is an established law school focused on child advocacy. And then I took that advocacy here to Las Vegas and called this place my home in 2003 with my children, my husband, and my families. When we came here, my first intention was to pass the bar, which I did. And I have 3.
Oh, what are the ages?
Our daughter is 22 years old, Genevieve, and our son is, he's already 18. He's 18, 19. So yeah, I'm still in denial sometimes. Our son is 19, and our little one, Emmanuel, is 14.
Tell us about your husband.
My husband is a disabled American veteran who served in our U.S. Army. He's a 5th generation military. Okay. So our family, the Nicholson family, is military. My husband served, actually, when he and I met, I was a law student. He was stationed in Barstow and Fort Irwin. He was a squad leader for the maintenance division. And I think I shared that with you. For the first 8 months of our marriage, it was a weekend military wedding, military marriage, where at 5 o'clock, when he's off shift at Barstow, he would drive to San Diego to be with me, and we would be together from 10 p.m. Friday night until 1 o'clock in the morning, Monday morning. Then
got it all
leave.
timed, huh?
Always time. It took him 5 hours, no stops, and he would.
No need to take a pee-pee break.
No pee-pee break. No. Every minute counted for us to be together, and it was bliss. It was like a honeymoon for 8 months, honey. February till October, so 8 months. Okay. I was in law school. He was in the military, and it was wonderful. That was the start of a wonderful family. We had challenges. He was disabled. He was honorably discharged from the military in October of that year, right before we were getting orders to go to Germany.
So he's 100% service connected.
He is 100% service connected. It took a challenge to fight for that, though.
And you know something? That brings me to my first question.
Absolutely.
So a veteran's service-connected disability benefits, you can't tax it, you can't levy it, you can't put it in the bankruptcy, but yet there are family court judges that take it for alimony. And we had to pass a law in this state saying that you cannot take a military disabled veteran's benefits to pay for alimony. So we had to pass a state law because the judges in family court wasn't following the federal law.
Wow. Wow.
So how do you feel about that? That some judges and attorneys will take a veteran's, like your husband, disability benefits for alimony, child support, or what have you?
Well, first, let me applaud you and Veterans in Politics for pushing that legislation to take what's federally mandated and apply it and codify it here.
And the legislator that helped do that was Assemblyman Jim Wheeler.
Thank you, Assemblyman Jim Wheeler. On behalf of, as a military spouse myself, and my husband having served 5 generations in the military, I thank you for standing up for our veterans, those who served our country, not just the men and women that have bravely served our country, but the spouses and children whose husbands and wives were sent abroad, sent everywhere else to, sometimes we don't even know because we're not allowed to know, to give their lives for our country, so that we can have the freedom to sit here today and talk about these things, or so that judges can have the freedom to apply the law to the facts and attorneys can advocate for their clients. So you hit home for me because the military standing up for our veterans, looking at my husband and, our family, it's something very valuable to me that I do believe that what our veterans receive as their disability for having served our country, getting injured from my husband from some lumbosacral sprain to now being 100% service-connected disability where now he needs crutches or a wheelchair to be able to move places, and he's still so young. And now the challenge that my children had to have of not having a dad that they can go and, run and play baseball, throw football around, the typical things that my kids aren't able to experience. All of that is a sacrifice for serving our nation.
Tell us about your husband's injury.
Do I have your permission, honey? Okay, thank you. I honor his privacy.
I get it.
So
thank you for doing that, by the way.
Absolutely. It started off when he was in the maintenance division. So he's squad leader for many in the maintenance division here in Barstow. That's where they're carrying 2-ton trailers and Humvees and all of those parts. He was really integral in making sure that our team can go and do what they need to do. And when they were carrying, I think it was early in the morning or middle of the night, they were all carrying a 2-ton trailer, and the rest of the squad dropped it or put it down without letting him know. And that was the start of pulling his back out. Pulling out what started as a lumbosacral sprain and strain. And when he was injured in the military, I think they only coded him at maybe 10% at the time, when he was very obviously in pain. My husband is a strong man. He's not the kind of man.
What's your husband's name?
Greg.
Greg
Nicholson. Greg. My family name, Parladè, is what I use for my profession because of the Parladè lineage of attorneys and politicians in the Philippines. But my married name is Nicholson. And he's a strong man, but he was in a lot of pain. And they gave him some challenges.
So your husband is on crutches.
He is now on crutches.
He's also in a wheelchair bound.
He is. Right here, we just use the crutches because it's not a far distance, but anywhere else, he's in his wheelchair. But it took a challenge to get there.
So your veterans like your husband is what some of these family court judges taking their benefits away. And I could say that with a clear conscience because I've seen it. I've seen it happen time and time and time again. There's also another judge that, are you familiar with the Service Members Civil Relief Act?
Slightly.
Okay. Let me just, for people that don't know, that says that if a veteran is out of the jurisdiction, it's an automatic stay.
Yes.
That means nothing happens.
Absolutely.
Until the veteran gets back into the jurisdiction.
Yes.
So we have judges down the bench that will violate that Civil Service Relief Act and proceed with the trial without the veteran present. And the veteran loses their home, loses their pay, loses their kids. We have, and I'm just going to be upfront and honest with you so you could understand the process that we had to go through since 16. We've been doing this. We have a former judge, Bill Gonzalez, okay, that told the veteran's attorney, this veteran's in combat in Iraq, and told the veteran's attorney, you better get your client on the phone and call me, or else he's going to lose his kids. Now this guy's in combat. So the attorney goes, you know what? He's in combat. What are you doing? Well, I don't care. Have him find somewhere that's non-combat and call. So now this judge was off the bench because we publicly showed what happened with him. And he tried to come back on the bench again, and we publicly showed what happened with him. So he didn't come back on the bench again. Now he's trying it again. What do you say to and I know I'm putting you in a difficult spot, Marie, but I have to, so you could clearly understand what's going on. And you're married to a veteran that's disabled, 5 generations.
Yes.
What do you say about judges like this that blatantly violate federal law?
The role of a judge is to apply the law to the facts, period. Mm-hmm. If the federal law is the law, and if state law is silent, then federal law applies. I like how what you guys have done is you've taken federal law, codified it into state law. So now there's federal and state law, not to mention the veterans in our families. Mm-hmm. So it's simple. It's to apply the law to the facts.
But if we have a federal law, it trumps all state law.
Federal law, state law should be in alignment with federal law.
Mm-hmm.
If our state law is not, then we need to take that to the legislators and fix that. Mm-hmm. Our state law can be even more stringent than federal law. Mm-hmm. And that's not my role. That would be the role of the legislators. The role of a judge is to apply the law to the facts. I can't speak for the decisions that were made by the judges that have been elected. And I apologize that I can't speak to
I know.
to that.
I know. I just want to let you know what's going on.
Absolutely. But I can tell you that I'm cognizant firsthand of the challenges that our veterans face, just trying to be compensated for the disabilities that they incurred while serving our nation. That was a challenge in and of itself for my husband and my family to try to get the compensation for him now being dismembered and parts of his body's not working. That income that he's receiving, his disability income, that belongs to him. That is to compensate him from our nation for what he did to fight for our nation. Now, if there are laws that are silent or laws that are going against what you and I both agree needs to go to our veterans, then I encourage that we need to talk to our legislators and try to get the laws more stringent, because as a judicial officer, when I'm elected as your jurist, my role will be to apply the law to the facts. And looking at what federal law, Civil Service Members Relief Act already says, and apply it to the facts. I can say that when I sat as a jurist, when I did sit as an alternate hearing master for about almost 4 years. And I did have a case where there was a member of the military. And, in these child abuse and neglect cases, they happen so fast. When a child is removed from the home, that initial hearing has to be within 72 hours. It must mandated by law so that we can determine whether or not we can return the child back to the parents or place the child in foster care. Upon noticing that there is a member of the military that was not present, while I could not hold off on having the hearing, I did make sure that one, he was notified. If he was notified, counsel was appointed for him, because in this case it was. I can't speak to the specifics, but the best thing I could do was definitely give him counsel and make sure that there were no decisions that would prejudice him. Like find out first and foremost, does he have family members, right? We obviously can't place with him right now because he was a man, so I'm speaking at least that much with specifics. I obviously can't say, we'll keep the child the child was removed from the other parent due to an unsafe situation the child was in. There was no prejudice to our military member for where he was. My goal was to, one, keep this child safe and not return this child back to an environment that was unsafe for this child. Number two, find out from this military serviceman if he has any family members. Does he have moms, dads, aunties, uncles, brothers that would like to come and serve in his place for this child? I can't order him to come back. He's on duty. But I do want to make sure that his interests are served.
Marie, we're going to...
just don't tap it.
I'm sorry. Okay.
We're going to be hard on you.
Okay.
Yeah,
Okay.
I got questions.
And let me just full disclaimer why, because in 2016 when this all started for us, there were many of those judges, veterans in politics, put on the bench.
And that's what I meant.
Yes.
And a lot of them in our opinion, we believe that we're doing an injustice to litigants before them. We have judges in family court. And we have a YouTube channel that has a lot of core videos on it. In fact, we have two. In case they try to shut one down, we have another, because they try that. Unsuccessful, might add. We had a judge, because you talked about Constitution.
Yes.
We had a judge that told a litigant, the Constitution does not apply in my courtroom. Verbatim. Family court judge that said that to a litigant. What do you say about that?
First, as a licensed attorney, we take an oath. We can't become judges until we're attorneys. And as a licensed attorney, I took an oath to uphold the United States Constitution and our Constitution of our great state and the laws that are here that are applied in our state. As a jurist, I sat as an alternate hearing master. That's like a judge pro tem. I sat for 3.5 years for child abuse, delinquency, family court, domestic violence, TPO. In every single one of those cases, I must uphold the laws of this nation, the laws of the state, which includes the Constitution. I can't speak for whoever it is that you're speaking for, but I can tell you I can only speak for myself, and I know that the role of a judge is to uphold.
But I just want you to know what's going on in family court.
Yes.
We feel that because family court judges have way more discretion than the civil criminal judges. You know, and I feel when you have this discretion, you bring your personal bias, because that's what discretion is. It's a personal bias. It's how you feel and how you interpret, how you think and how you see things. But they don't follow the law. They bring their discretion and not following the law. There are many of them, they don't even follow the rule of evidence. If an attorney that they like, all glamour, and gave to their campaign, that's the attorney they're going to listen to. 65% of litigants in family court are pro-per. So they would listen to that attorney who gave to their campaign, who dresses up nice, I got you, and not listen to the litigant who's just trying to fight for their kids. What do you say about that?
In addition to upholding the law, custody court, for example, in family NRS 125 relocation statutes. Mm-hmm. You know, I know we're not talking about that right now, but that just comes up a lot in a lot of matters. And, you know, before a lot in the NRS, what I like about the NRS is there's a preamble at the very beginning. And in NRS 125, for example, on relocation and on custody statutes, there's a preamble there that says that it's presumed, right, to be, number one, the best interest of the child is the paramount concern. Not the parents, not the attorney's fees, not the who voted in your campaign.
But how do you determine that, though?
The best interest of the child?
Because that's the thing that, like, really confuses me is because okay, let me just phrase it this way. What makes you uniquely qualified to be able to determine the best interest of the child? Because I've seen so many family court cases and we've had so many litigants on that there's this natural thing, right? So like if the judgment doesn't go the way you want it to, obviously you're going to be upset. You're going to think there's something wrong. But especially with, and I hate to bash her more than I already have, but like Judge Steele, there's just so much discretion in family court. And they just use that as a cop-out. So I need to know from you, like, what uniquely qualifies you to be able to understand what is in the best interest of the child.
Absolutely.
Because what ends up happening is, okay, say I'm Steve's wife, and I'm like, okay, Steve's this raging alcoholic, right? With no proof of that. And then all of a sudden you're like, yeah, okay, well, you need to go get these tests done, or psychological tests. And it costs Steve tens of thousands of dollars. Mm-hmm. But these judges are saying that's how they're doing their due diligence. Does that make sense?
That what you just described does not make sense, but I know that what you're describing
right.
is
right. Okay. Yeah, good.
But what uniquely qualifies me for that is, I think, your question. And as I was saying earlier, I represented children from the very beginning. That was my first perspective, my first lens. My mandate is to apply the law to the facts as an impartial, independent arbiter, jurist. Right. But we also recognize that we're human, and I'm not going to let my religious, political, moral convictions get in the way of making a decision for a family. But I can tell you that there's a lens of discretion because of my life experiences that I've had, representing children for over 20 years, being the voice for the children, recognizing that these children, you know, in custody matters or child abuse cases, they want to go home to their parents no matter what. And sometimes it would conflict with me, because I'm like, no, this kid can't go back home. It's not safe. This kid can't go back home. But I would have to advocate for what my client wanted, recognizing, though, that what I was doing was giving me a different perspective to look at things through the eyes of the child. I can't sit there in court representing for my child what I believe is best, because now I'm supplanting my child's wishes and my legal mandate with my own personal convictions. That was the first level of lensing or training that I received. And I believe it was the best, because we need to understand from the view of the child, you know, their safety, their security. Maybe they'd rather be home in a place where it's not the perfect house. Maybe there's some mess. Maybe there's, you know, they don't have everything that they need, but it's home. And it's where the family is, as opposed to going in some prim and proper stranger's home, that is not in the best interest of that child. And so that's my first lens. And then when I came here to Nevada, I represented children pro bono for many years, received congressional, senatorial recognition for this, but that wasn't why I did it. I cared so much about these kids. But then it got to a point where I wanted to do more because my representation of children was just one little segment. And there came a point where what was best for this child was contradicting what the child wanted. And that was my first level of training, of moving myself out of the way to really understand what this child wants vis-a-vis all of the other circumstances in that home. And that's when I was invited to serve as a judge pro tem, as an alternate hearing master. I had my own law firm at the time. I was still very green. I was only maybe 5 years in as an attorney representing children, but I cared about these kids so much that I would sit in court and ask for the next case to be assigned and the next one. And the judge would say, dear, you have to go through the legal aid center, but we'll write your name down here because I just wanted to make a difference. Then when I sat as a judge, that's what gave me this different level of perspective.
So you sat as a judge in family court?
I did.
Judge pro
for 3.5 years, to a point that I had to close my law practice down because it wasn't a matter of if I would sit, but which court I would accept, because I was getting calls for child abuse and neglect, delinquency, which is Judge Voy, who I'm his court, TPO court.
That's the judge you're replacing, Judge Voy.
I'm moving for his seat. Yes, absolutely. I'm vying for his seat. And he was over delinquency, over child abuse, over our sexually exploited youth. He did great. He left some big shoes to fill. Whether people like or don't like his personality, his temperament, he left some really big shoes to fill. And I can say that I've learned a lot from that realm. I served also for TPO. Those are the domestic violence courts that, where we have the uneven footing oftentimes of the litigants. Maybe we have the victim who doesn't have counsel and is trying to get safety for herself and her children, but yet she's put up against, someone that has an attorney and that has all the resources. I've seen that unequally yoked, unequal playing field. And I never lost sight of what's important, which is protecting. One, if there's children, protect that child, right? What's the best for this child? And two, recognizing the interests of the people that are here. There's competing interests before me. And let's take domestic violence court, for example, because that comes up a lot as a factor in many family court custody cases, whether it's accurate or it's just an allegation, right? That and drugs and mental health, because...
Let me stop you right there, because you brought up domestic violence. A family court judge is a civil judge, correct?
Correct.
Domestic violence is a criminal act.
Right.
Why is domestic violence in family court? Shouldn't that be in criminal court?
You're correct. There's two types though. The crime of domestic violence, of whether or not the crime was committed, is tried in criminal court. The repercussions of the domestic violence on how that crime has now affected the victims and the collateral damage of the children is in family court to look and assess the safety and security of the family.
Good explanation.
Absolutely.
Good explanation.
I'm like, wow.
Very good. I'm not even going to argue with you.
I was going to say, hey, finally somebody could explain.
If I can elaborate on that even more on the child abuse side, because many folks don't know this. When a crime of child abuse is committed against a child, it's handled in 3 tribunals, right? There's the criminal court charging them for child abuse and neglect. The burden there is beyond a reasonable doubt. And then at the same time, concurrently, CPS can get involved, the district attorney can get involved and file a petition in family court. This is where I presided for child abuse and neglect court. That petition is to allege that this parent abused this child, and the repercussions of that, if it's not abated and fixed, is termination of that parent's rights. That's a different standard. I sat and served in there. That standard is clear and convincing evidence for termination of parental rights. But there's a third tribunal that many people don't know about. In addition to going into criminal court for losing life, liberty, and going into family court for potentially losing parental rights, there's also a third tribunal, which is the administrative law side. And that's where I currently preside. And on the administrative law side, the Child Welfare Agency can find that after doing the investigation and talking to collaterals, can find that the parent committed child maltreatment. And maybe they're finding that maybe it's not enough to go into family court because this father doesn't want anything to do, or maybe it wasn't even a father, maybe it was just the boyfriend. So he doesn't have any parental rights at stake over this child. So this boyfriend that harmed this child is not going to have a petition in family court to terminate his rights. But the Child Welfare Agency can enter his name into the Central Registry for Child Abusers. And that's a statewide registry, and every state should have one. And if his name is entered in there, he will no longer have access to children in the form of being a teacher, working in childcare, or any of those professions that require that. And in each of those tribunals, there's a different burden of proof. I currently serve on the administrative law side of the house. I'm over the legal division there. I have families that have filed appeals, and those appeals come to me, and I assess the law and the facts. I look at what's in the best interest of this child. I look at the evidence to see if it met the muster of the burden of proof. And if it didn't, if the agency failed to establish that proof, maybe in your gut you feel like something happened, but they didn't document the evidence. They didn't get the police report. They didn't talk to the witnesses. And it's just a simple statement. I overturn. I have to overturn even the hand that feeds me, my own agency, because my role is to apply the law to the facts, regardless of who's paying my bills, who's paying for my campaign, or who's coming and buttering me up. It's a strict application of law to the facts. I did that when I sat as an alternate hearing master for 3.5 years in multiple courts, which gave me multiple perspectives, and to a point that I had to close my law practice down. I do that now, again, putting our children and families at the forefront.
So Steve, if you don't mind, I just got one quick question. I really appreciate everything you just said. But, okay, so the counter argument, unfortunately, is going to be this. Obviously, you're very knowledgeable. I've done my research on you. So and it's interesting you brought up Tom Womack. I actually talked to him about you. So anyway.
Oh, my boss.
Yeah. So anyway, here's the thing. Like everything you said.
On the contrary. Tom Letitia is your campaign manager.
Yeah, I'm sorry. I joke that he's my boss.
Or the boss.
I am the boss.
Whoever is writing the check is the boss.
I am.
Okay?
I'm just kidding.
Make sure you are the boss.
I am. I am the boss.
Please continue.
Thank you, Steve.
So like everything you said is really on point. One of the things that is an issue though is time frame. So you're taking all that stuff into consideration and you understand how the process works. But unfortunately, time frames and we've seen it with, I've seen videos where, with Steve observing with the Veterans of Politics, court observers. And I've done it a couple times myself, where it's like the judges seem so overwhelmed that they're like, oh, well, I don't have time for this. I don't have time for that. So I don't know where the threshold comes down of where the line is drawn to where that's either becoming a cop-out where the judge is just lazy or if it's something legit. So what would you like to see to help alleviate some of the not constitutional 6 months time constraints with family court, but so that a judge is able to actually bring all that in and actually do their job?
Absolutely.
Because all that sounds really good, but there's so many court cases right now in family court that these family court judges are overwhelmed. So how would you construct your calendar in which you could bring all that into consideration, but at the same time, keep a proper time frame?
Absolutely.
Because justice delayed,
right?
We've
Absolutely.
all heard that.
Absolutely. And our families come to the court system not because they're all good and everything's rainbows and unicorns.
Right.
They come to the court system because they need help. And they're asking for justice to be served in a timely, speedy way, especially in family court, where it's the most vulnerable of our families. Right. If you look at all life, liberty, pursuit of happiness, but family, that's the core of everything. And so I'm glad that you asked that. And, I'm a firm believer in holding the hearings when they're there. I know there's times where people are going to ask for continuance, but I've seen continuances being given out like it's just a free pass. for anything and everything.
Let me just stop you right there. Isn't it supposed to be, according to veteran rights statute, 6 months from the time it starts to the end, till it ends?
It should be, yes.
But why are these cases going on from toddler to graduating high school, some of them?
Are you talking about the child abuse and neglect cases or the family
court? Yeah. From toddler, I've seen one case is going on 12 years.
Right. And while I can't speak for those cases, I can say that we need to apply the law to the facts. Law says families deserve to have closure, decisions, dispositions being made within those 6 months. We need to do a better job of this. I can say that on my experience, because, again, I'm not here to speak about all the other judges.
Right.
But I can hold myself accountable.
We are not trying to bash you or it's not a got you.
Right.
We're trying to let you know what we have seen.
Absolutely. And I appreciate
because we got blindsided by all these judges we helped put in office and then not doing the right thing.
Absolutely.
Our litigant base is several thousand. Several thousand is our litigant base.
Yes.
And a lot of them are going to be watching this show.
Absolutely.
And they want to know that whoever they go to the ballot box to check off, that person, without a doubt, is the best person for that position.
Yes, absolutely. And I appreciate you guys.
So we gotta
have you.
We gotta ask you those tough questions that they want answers to.
And I'm going to hold myself accountable and share with you guys what I can base this on is my experience. I can say all these things to you, but I can also give you my track record because I have sat on the bench for 3.5 years. And on those cases, I don't control my calendar. I was coming in to fill the spot for someone else. And on those cases, those were truancy court, for example. I had to do truancy court. I had upwards of 500 on my calendar. That's impossible. How do you get through 500 people in one day, 500 youth in one day? But you know what? It's the task that's given to you. You have to get it done. We would do it and we would move forward. On our child abuse neglect cases, I would have so many cases stacked on a 130 setting, and yet there's pages and pages of names, 20, 30, 40, 50 families that have to be heard at the 130 mark. And so how do you prepare for that? I'll tell you what I did. Even though I didn't get paid for it because, again, it was a vendor. I would go into the court ahead of time. And I would not just read. It wasn't enough for me to just read these files because I needed to see the body language. I needed to see the hearings because that's how invested I am in these families. I want to do right by them. They're coming before me to make a decision about their case. I can't just base it on some cheat sheet of what the prior judge wrote or what's in the court report. So I would read the file and then I would go and I would watch the jabs tapes. No matter how long it took, I would stay there late nights. My husband can attest to it because he'd be like, "When are you coming home?" I'm like, "I'm sorry, honey," but I would be on the bench till 5 or 6. I would. I mean, he can attest to it. My calendar would end at 5, sometimes 6. If we have long cases, and I was sitting on the bench for assignment, so like a 2-week stint. If a judge is going on vacation, I was the most called for, so I always had assignments. And so after being on the bench, I would go back upstairs to the chambers and I would watch the tapes for every single court hearing. I would be there late at night. Sometimes I got scared. I'm like, "Honey, I'm scared to walk to the parking lot right now." And then he would say, "Well, what?" He would say it in not so nice. He would use his military language.
But you guys have the judges have their own private parking lot, right?
We did, yes. And so, and there was always a bailiff. There was always someone there. And, they were all so great. They would always walk me. But I say this because I didn't do that to get paid. I didn't get paid for that. I tried at one point putting the hours, but I felt so bad because the county's like, "You did what?" So I just did it. But I did this because I cared about the families. Yeah. And I did that for not just one hearing. For the 3.5 years, I presided over thousands of hearings. If you need the stats, I'll have to go back and get it. But I can tell you, I presided over thousands of hearings. I presided over trials where the families' lives are in my hands. I take that seriously.
Okay, so my next question is, in my opinion, and now I'm not an attorney, but we've interviewed like so many people at family court and stuff, and Steve's get me more up to speed on the proper language of how to ask questions. But in my opinion, a lot of the problem with family court, besides the fact that most family court judges don't follow the state or federal constitution, but that we've already beat that drum. So when Steve was talking about 6 months. One of the issues that I think floods family court judges and puts way too much of a burden on family court judges and the process in general is vexatious attorneys. Okay? Attorneys never seem to get that label, but pro se litigants, judges are like, oh, throw this out. This is vexatious. Why do you keep filing all this stuff? And it prolongs this stuff forever.
It's a constitutional violation because it ties the litigants' hands. They can't file. They can't either defend themselves. So is that really a court of law? What happened to the 14th Amendment, the fair judiciary? That kind of threw everything out. Yeah. So how does that even apply if a litigant can't defend him or herself because they're labeled vexatious?
Well, there's a thing called the Nevada Rules of Civil Procedure, Rule 11, and it's called, a lot of attorneys know it, they're called Rule 11 sanctions. And the NRCP 11 states that an attorney, before filing something, they must ensure that it's not submitted for purposes of harassment, right, or undue delay, and it's not and that it is grounded in law, or if it's not grounded in law, it's with a good faith argument to address that there's a flaw in the law. Even though I think activism, that's for legislators, not for judges. Right. And it has to be in good faith. And it has to have some basis of evidentiary support or reasonableness to there. And attorneys, when they file a document, and don't quote me, you can look at NRCP 11 itself, because there's probably a much more language. I really gave you guys a short paraphrase of it. But that, as every attorney who made an oath, we can't just file vexatious complaints for the purpose of, trying to bombard, litigants, pro pers especially.
I could tell you one attorney that comes to mind, because it's personal, because I've seen him do it in my cases. Abusive process is Marshall Willick. And let me make a point of order, because when I was talking to you about judges that were giving away service members disability benefits, Marshall Willick was the ringleader in that. He was the one that pushed it in the legislature to take away veterans service-connected disability benefits.
Yeah, to pay his retainer.
And he also takes away disability, civilians' disability benefits too. There's several cases that's going on right now that he's trying to take away their disability pensions and disability benefits. This is these are the type of actors, is what I'm best want to describe them, that are in family court. And these are the type of actors a lot of judges respect, which I find it disheartening that they would go and let this type of person rule the roost, basically.
It goes back to the role of a judge, to apply the law to the facts, impartial, independent, with integrity. I can speak for when I sat. I've had these family court attorneys come into my courtroom. My courtroom was, whether it was abuse or neglect or TPO in each of these different realms. I've had them come in and try to
railroad.
Yes. And, but you know what? It doesn't scare me. My role is simple. My mandate is clear. Apply the law to the facts. What's in the best interest of this child? Not what's in the best interest of your attorney's fees or whoever you are. It's about the child. And if the child is not in the case and it's really a divorce dispute, it's weighing the interest between the husband and the wife or the two people and what's in the best interest. How can we best serve? Because it's not about, the court should not be used as a place to allow bullying and intimidation. Now, I'm not saying that, I'm not validating what you said about Mr. Willick or any of the other folks, because I wasn't there. I don't have personal knowledge. I have utmost respect for the judges, the judiciary, and the attorneys that take their oath. But I'm also well-versed. I'm not naive to this. I've sat for 3.5 years. I've sat for all the different types of courts that are in there, and I enjoy that because it gave me perspective. It made sure that I was not comfortable. I wasn't anchored in one spot. Because before I know it, I'm in another court and another court. And wait a minute, it's the same players. It's the same people. Why is it the same pattern of behavior? So I am familiar with that. But I can tell you, and you can look at my track record, I will not get railroaded. It's about the kids. I've been fighting for children for 20 years, ever since I was a law student. I'm not going to let one person one up what's best for this child.
Sorry, Jim. We determined that a family court judge is a civil judge.
Mm-hmm.
Okay. So there are some family court judges that are locking up people for contempt violation. If they are supposed to be a civil judge, why are they making criminal decisions and putting people behind bars? Shouldn't they move that contempt case? And you know what? And it's biased because they're the ones that says, we're going to have a contempt hearing, sir. So if they're the one that's ruling that they're going to have a contempt hearing, that means they already have a predetermined notion of what they're going to do in a contempt hearing, because they're the ones that wants a contempt hearing for whoever's before them. Shouldn't they remove that from their court and put it to the judges that handle criminal contempt? And you know what they say? Well, it's civil contempt. But if you're going to lock somebody up,
It's their life, liberty, property. That's their thing. Yeah.
a jail cell does not know the difference between a civil contempt and a criminal contempt. A jail cell just locks you up.
Mm-hmm.
So they're supposed to take those criminal cases and send it before the justice of the peace,
Mm-hmm.
instead of keeping it in their courtroom. And they're the ones that orchestrated the whole contempt hearing
Mm-hmm.
to even be in their courtroom from the very beginning. So they already have a predetermined notion of what they're going to do. They're going to lock you up, Jim.
The justice system, judges especially, need to be accountable. So, for example, on the Rule 11 sanctions that I was telling you about, Rule 11, NRCP Rule 11, that attorneys are bound by. Did you know that in there it even says that a court can sua sponte, place a litigant on notice that they're going to be held in contempt for Rule 11 sanctions? I mean, I'm not using the right terminology, but you can look at NRCP 11, and it allows that even a court can hold a litigant responsible and accountable. So if a court can hold a litigant accountable for sanctions before it in the form of Rule 11, putting frivolous motions before there, then there has to also be something that holds the court accountable, because that's the nature of our government, of the checks and balances that we have.
But nobody exercises that though. They don't hold the court accountable.
There are motions in the law. The law is the recourse.
Mm-hmm.
And a judge can file. You can file a motion for reconsideration. You can file a motion to recuse. You can file. We filed one. I can't say the case, but we had a case, and we felt that the judge was biased, and so we filed a motion to ask the judge to recuse, and we served it upon the judge, and to protect the judge and to protect the integrity of the judicial system, we filed that under seal. With permission to file it under seal to the judge and the chief judge, to ask them if, this is a confidential case, so we don't want to put all of this out there because it was dealing with children and confidentiality, and, we don't want to parade and exploit children's cases for the sake of trying to one-up an attorney or one-up a judge. I believe that their sanctity and their peace is so deserving of the utmost protection. And so when we filed that, the judge recused, and it was placed in the hands of another judge, and we're entitled to a fair hearing. Judges need to be fair, impartial, and equitable.
Yeah, with the 14th Amendment.
Absolutely. And so the laws are there to protect. And so sometimes it's just a matter of using the vehicles, the weapons that are there, which are the laws, to go and launch that counterattack to ensure that justice is served. And there's also the judicial canons. There's also the judicial discipline. And so I say this because, government is set up to have these checks and balances and these levels of accountability.
I don't think the judicial discipline does their job. They already said that they're underfunded. I remember with the Judge Jones case, they said they used their whole annual fund just to try him. So judicial discipline is not an organization that really do what they're supposed to do. They're supposed to do the people's bidding, and they don't. And I can honestly say that because I have filed against judges. I have filed, oh my God, lots. lots of judicial discipline cases against it. Some got through, but many have not. And I gave an evidence. We have one family court judge that's on the bench right now. Bankruptcy fraud, mortgage fraud, and perjury. Still sitting on the bench.
And that's where you can file a motion with the chief judge.
Oh my God, I've done that. Chief judge,
Still.
AG, Nevada ethics, judicial discipline, and anything that you could, FBI, bankruptcy trustee. I went through the whole ringer.
Yeah.
But yet they go after Ozzie Fumo for saying that one of his colleagues, at the time, he wasn't Supreme Court justice back then, was a white supremacist. But yet they won't go after a judge that's bankruptcy fraud, mortgage fraud, and perjury. Go figure.
Well, I know you're not going to give up.
No, I'm not.
So there's always
I
another
did
door.
billboards on the judge too. That's how
Absolutely.
upset I was. But
And maybe this is a good time for legislation, right? Because
Yeah.
you had an assemblyman that backed you on one of the bills. You know, when
we got another bill. We got another bill. It's called Remove and Retain.
Okay.
How this works is we put it in the last session with Assemblywoman Titus.
Yes.
The way to remove and retain works, you know that a lot of attorneys don't want to run against a judge because they're scared, because they got cases in front of that judge. And this is how they make their livelihood. And that judges have friends in other departments, and they got cases in that department. So they don't want to run against a judge. A judge, you can't recall a judge. Supreme Court ruling came down from the Catherine Ramsey case from North Las Vegas. You can't recall a judge. Although a judge is the only elected official you cannot recall. And I don't think the Supreme Court should have been involved in that. It should have been the legislative branch, not the Supreme Court. But anyways, you can't a judge that has no term limits. There's no term limits for judge. A judge has judicial immunity. So how do you get rid of a bad judge? Judicial discipline is not doing their job. How do you get rid of a bad judge? And they said at the voting box, at the ballot box, great. But if nobody runs against the judge, then what? One vote, judge is in already, right? For another 6 years, because the district court bench family court is 6 years. So you're gonna have that judge for another 6 years. So we came up with remove and retain. And the way it works is judge's name, under the judge's name is remove and retain. If remove gets more votes, judicial selection the bench is vacated. Judicial selection committee start taking applications, send 3 names to the governor. The governor picks one, and that person goes up for retention next election year. That's the only way we could remove a bad judge off the bench, because they're not going to go by themselves. What do you think about that?
It sounds like you have a possible legislative bill, BDR, that now its next step would be find a sponsor.
Oh, I got the
Push that
sponsor.
forward. Okay, so
Got the sponsor. It was in the last
Will we see-
session, but one of the committee chairs wouldn't let it out committee.
and so you will go back in. 2023 is around
But
the corner.
how do you personally feel about that?
As a judge, I'm not allowed to legislate from the bench. I have to apply the law to the facts and hold close to ensuring my impartiality, my integrity, and my independence. What you just described to me is very disheartening. But for me, outside of my judicial role, I want to see justice served, and I want to see our families, our family court families. I believe that's the most vulnerable of the courts, because these are the livelihood, these are the families. They need to have justice served. And so if they're not receiving justice and they're not receiving a fair, impartial hearing from a jurist that's been voted in, and if they aren't able to go and find a different judge by the different various ways of filing a motion to recuse, a motion for disqualification, then there needs to be another level. And if this legislation is the next piece, then I'm not going to say excited. I applaud you.
Thank you.
For your advocacy, for standing up for the 7,000 litigants, the veterans and the families who need justice. We will not just roll over. And I'm speaking we now, not as a judge, but as a member of my husband.
A lot of people don't even know about this stuff that happens in family court. They're like, really? They don't know about it. But I have another caveat to remove and retain. It's called a jury box.
Oh, you took the question, Steve.
A jury
That
box.
was my fault.
If you go to these family courts, there is no jury box. The 7th Amendment said you have a right to a jury. The 14th Amendment said you have a right to a fair judiciary. Why isn't jury boxes built in family court? And because as one person wants to make this decision, I don't think that one person should make these decisions, especially when it comes to relocation of children and termination of parental rights, because both of those are civil debts.
Right.
Divorce is a civil death. You take somebody's kid away is a civil death.
Right.
Why does one person have that much power, could take away your child for the rest of your life? Why does one person have that power? Where is the jury?
That person should have been voted in by the people, and that person has the duty to uphold the laws and apply it in a fair, impartial way. Now, I know that the jury is even listed in our Constitution, but it's been interpreted to apply for criminal as opposed to family and civil. I
They
believe
use it in civil court. They use it in civil court. I mean,
Right.
$1 million, multi-million-dollar cases, The Win, Sheldon Adelson,
not
they
in
all
family.
been in civil court.
just not in family. And so this is where, again, legislation separate from judicial. The role of a judge is to apply the law to the facts. Possibly here, this may be another avenue for legislation to take what's already as the baseline there in our Constitution and translate it and codify it into a statute that applies for family law. Because oftentimes what we see is we have these federal or these large grandiose statutes or these grandiose ideals that are in the Constitution, that are in federal law. But if it's not codified with the specificity that's needed in the state law, then that's where you have that wiggle room because it's not written there in black and white.
You know what people tell me? They say, well, family court is a delicate matter. It shouldn't be
absolutely is.
public. And I'm like, well, have you been to criminal court and look at these rape victims and these molestation of children all in criminal court and it's open to the public? So what are you trying to tell me, really?
Right. And that should be the family's decision, shouldn't it?
About
whether they want their information out in public or not. About whether they want to have a jury box or whether they want to have a judge.
Well,
if we were to get to that
jury
place.
boxes, I say, yeah, it should be their choice about jury
Right.
box. But a courtroom is paid by taxpayers. Judges are paid by taxpayers. The janitors, the JEA, the law clerk, the marshal, all taxpayers. It's a public courtroom. And it should stay a public courtroom. There is a case up in the Supreme Court right now about keeping videos and stuff public because it's a public courtroom. This is what I tell litigants. If you don't want to air your personal stuff out in public in a public courtroom, then you best go mediate it in private, draw up the documents, sign the papers, and have the judge sign off on it,
Right.
and you be done. Instead of going to a courtroom and fighting and putting all your personal stuff on the table.
I see what you're saying, but I also have a counter argument.
Sure.
What about the domestic violence victims that are scared to come out because of fear of intimidation, fear of retaliation? They probably don't even have the financial resources to be able to get out there to get the help. But somehow, some way, they go to the domestic violence advocates, they go to Safe Nest, and they're told, you know what, we'll help you file a restraining order, we'll help you get exclusive possession of the residence because you're entitled to it and get custody of the kids. But they're terrified of just anybody knowing. Maybe it's cultural, maybe it's just because of what they've gone through.
But then that goes right back to what you had already talked about is they should have the right to decide. Like
Absolutely.
if they don't want a jury trial,
Right.
okay, fine. They can say they don't want a jury.
I agree.
But right now it's not even an option.
Right.
So what we're trying to say is shouldn't it at least be an option? And what's your opinion on that?
Yeah.
Because honestly, I really appreciate all the way you've answered all these questions. But and I do understand that you got to be careful with, what a judge can do and what the legislature could do. And I appreciate that. Because finally somebody understands how the Constitution works. God forbid.
Yes.
But at the
That's running for family court, Steve.
Right.
Yes.
But at the same time, your opinion is also very important because you will be given a lot of discretion as a family court judge. So when it comes to jury trials, my opinion, now Steve can tell me if his is different, but I think we're on the same page on this one. Right now, there's not even an option. At least make it an option. And I talked to a retired police captain, and he said the reason why jury boxes aren't in family court is because it was too expensive. Too expensive? I mean, we are a land of laws. And if we are violating the 7th Amendment and the 14th Amendment by not at least allowing the option. So that's all, but at least that's what I'm trying to say. Hopefully Steve's the same way. At least allow them the option. If they don't want that, or even a tribunal, like, because it is as smart as you are and as well-intentioned as you are, like, and I'm a well-intentioned guy, but I have biases too. So other opinions, like, so somebody else will have their own bias. So, like, at least have that as an option if it's not a jury trial, but maybe a judge's tribunal. So if the litigants agree to that as being an option.
These are all not, this is the first time I'm having this conversation with gentlemen, so I appreciate you allowing me the flexibility to essentially process out loud.
And we're enjoying how you're answering.
Yeah.
We knew this wasn't going to be an easy
and I'm
easy
sorry,
Goldilocks interview.
and I'm super long-winded, and Steve knows that. I need to be more poignant.
No, I love it. And
in
I'd
my
love
questions, but
I'd love to kind of,
we tell
continue
people,
what
but
you're
before
saying.
you go, we tell people, if you can't handle us, you should not be in politics at all.
This is a walk in the
Go
park.
away.
I enjoy, you guys are honest. I've actually gone face-to-face with John Ralston. When I was sitting as a judge. So I didn't say that, John, but I've gone face to face with him when I was serving as a hearing master to address implicit bias in the system. And that talk about courageous conversations. And I was just a newbie judge and I did that. And I went on set live face to face with him.
Yeah, because John hates the fact that we elect judges.
Ooh, yeah, and he went under my skin and he looked me dead in the eye. He said, "Is there really bias in the system? Are you biased?" And I said, "You know what? There's bias in the system. It's institutional, it's implicit, and not just in the court, not just in Las Vegas.
Everybody has bias.
Exactly.
So then based on then based on that, in your opinion, shouldn't there at least be an option for them to come to an agreement that, like, yes, either a jury trial or even, like, I would prefer a jury,
a bench trial,
or
a tribunal.
Something to at least kind of, like, get away from some of this this bias, because we all have it. I mean, it doesn't mean that judge is a horrible person. No. It just means that, hey, maybe more opinions and more world views and more things need to come out and be taken into consideration.
I'm not advocating from the bench. I'm not legislating or talking about activism from as a judge.
Right.
But, as a human being, what you're saying makes sense. And I'd be willing to, have further discussion. But honestly, I'm not the person that you talk to.
Right.
This needs to go to the legislature.
We just want to put it out there so you can know exactly where a lot of people are coming from that goes to family court.
But I do want to kind of jump on one caveat that you mentioned about the sheriff, where somebody said it's too expensive. Yeah. And, having worked in government, I also recognize operational needs. Sometimes there's things that you want to do, but you can't because there's no resources for that.
Right.
Going back to the expediency and time. Remember how we talked about we need to get things in 6 months and get decisions? Looking at how jury boxes would work, even if we were to get jury of 3 people, the time that it would take to gather the jurors, to get them positioned, trained, and everything, that would be another factor that could cause a barrier.
I heard that argument before, but look at all the time and money that's already in the family court to begin with. Like I said, we have cases 12 years.
Right.
Come on.
They need to.
I mean, so let's go violate the 7th and 14th Amendment because we thinking about time or we thinking about money. It shouldn't be an option in this country. Constitution should be there for everybody, regardless of time, money, commitment. It should be there for everybody.
I agree.
And we need an option in family court because what's going on right now, I could personally tell you, is not working at all. I've seen there are some litigants that commit suicide over this. Look at the cop in North Las Vegas that shot his son, killed his daughter, and killed himself. I mean, we're talking about people's lives here. There was another thing, because we already determined that a family court judge is a civil judge, not a criminal judge, okay? Why do you believe family court judges could tell a litigant to take a drug test? The reason I say that, because they have no jurisdiction. They have a family court judge is a civil judge. They cannot order a litigant to take a drug test. Judge Steele sat here and said the same thing and tell families that if that happens, they should appeal it to the Supreme Court. A lot of family court judges are pro per, 65% of it. They don't have the means to go. They don't have the knowledge to go to the Supreme Court. They don't have the money to go to the Supreme Court. They don't know that they could do it pro per. They think they have to hire counsel to do it. A lot of, speaking of drug testing, because I had litigants go before judges and say, I'm not taking a drug test. It's not because they're dirty. It's because it's a violation of their constitutional right. And civil judges don't have jurisdiction to order a litigant to take a drug test. So when they say, Your Honor, I'm not taking a drug test. So the judge goes, okay, I deem your test dirty. I deem your test dirty because you're upholding your constitutional rights. What do you say about that?
Well, it depends on the context. Let me give you some perspective on where this would apply.
Sure.
And I've dealt with this myself on child protection cases.
Okay.
When a child is being removed from a home and the allegations are that the parent is using drugs to an extent that it's harming the child, and we have a vulnerable young child here. In that case, that family is submitted to the jurisdiction of the court. The parent's rights are at stake here. If the parent wants their child to be in their care, the parent needs to establish that, one, I'm clean. That's a frivolous allegation. And they can do that one of two ways. They can take the drug test. It's their choice, though, to take the drug test to show that it's clean. If they don't take the drug test, it is presumed to be.
But shouldn't the law reflect that? I feel like they're circumventing the law. If the law says that a family court judge is a civil judge and the only one that could order them to take a drug test is a criminal judge, then they need to change the law. They can't circumvent the law because they feel, oh, well, this child might be in danger and that person might. No, you have to be in they need to go lobby the legislatures and make it so that a civil judge can also order a litigant to take the drug test. Not until then. It's, for example, I give you a brief synopsis. I got pulled out of my vehicle, okay? Because I told a cop that I had weapons in my car and I have a concealed permit. The cop searched me and go into my vehicle to take my weapons out of the vehicle. And I said, wait a minute, you can't do that. Well, I want to make sure that you're not a felon. He had all these things. I want to make sure that the guns are not stolen. No, you have no probable cause. You have no warrant. Right. So.
But it wasn't a search. It was a frisk.
It was a frisk while he was taking my guns out. It's all on YouTube. I got all the cameras with the Freedom of Information Act. But here's the thing. If judges and everybody's supposed to follow the law. If you don't like the law, go lobby it.
Change it.
So if a civil judge, a family court judge, cannot order a litigant to take a drug test, and they don't like that law, they need to go change it with the legislature. They cannot legislate from the bench like you're saying. And that's exactly what they're doing time and time and time again. And they can't tell a litigant, well, I deem your urine dirty because you're exercising your constitutional right and you know the law and you're throwing it in my face. They can't say that.
Back to the context, the example I gave you, though, because as a family court judge, when I sat for child abuse and neglect cases, and I had an instance where the parent was, there was a parent who was actually under the influence in my courtroom. You know, I could order that parent to take a drug test, and the parent could choose not to. And if the parent chose not to, I'm not going to put that parent in contempt. I'm not going to take away their rights. But recognizing that my jurisdiction was limited to whether or not this child was safe in that parent's care. That parent was under the influence in my courtroom.
I get it.
And so,
you saw that. That was before you. It was in your face.
Right. And my decision was limited to what's safe for this child. So, and the law in RS 432B does allow, it's kind of loose, but it says that the court can order any orders that are material and relevant for the best interest of this child. And I stand by my decision that day when I told that parent, I already knew that he was under the influence, but I did that because of the safety of this child. In family court, you're balancing interests. It's not just that parent's rights. I'm balancing that parent's rights to due process of their child against the other parent who's not under the influence rights to having care, custody, and control of their child. And I'm balancing the interests of this child. Who's going to stand for this child, of what's best for this child? And I'm balancing the interests of the state, right? To ensure that what we're doing is in line with the letter of the law. Right. And so I appreciate the examples you're giving me, but I have to share with you that in my instances, because I can only base it on my experience, I can't judge other people for what they've done. Right. But in my application of the law to the facts, you have my assurance. I will apply the law to the facts. I will balance the interests before me, whether it's the litigants, the children, and the state, to ensure that at all times I'm upholding the Constitution, the letter of the law, and my oath that I take very seriously. I did that when I was serving as a master for 3.5 years. I wasn't appealed. I wasn't brought. There were no complaints that were filed against me. I served as a hearing master. I enjoyed it. The only reason I left is that's for another talk show. Right. But, I got a wonderful offer at the department, and they literally hired me to create my job out of thin air and to create the legal division where I still do appeals and decisions. And I'm also behind the scenes on legislation, which is why you see me getting a little excited about legislation, because I believe that there's a lot of laws that need to be passed still. And I applaud you tremendously, both of you and Veterans in Politics International, for standing up for the rights of our heroes and our veterans and not giving up and not allowing one shut door to stop you in your tracks.
You know why a lot of people don't like to come to our endorsement interviews? Because they don't like the hard questions. I like them.
These aren't even hard questions. Tape. They're honest questions.
Because they can't handle it.
Wow.
And when they don't show up, that tells me that we don't need to vote for that person.
Right.
And I appreciate you sitting here, taking it from both sides.
Absolutely.
And answering the questions and not trying to skedaddle out of it. No, well, thank you for doing that.
You're welcome. Thank you for trusting me with your questions. I don't take this position lightly. Mm-hmm. I am a public servant. I've been a public servant. I work in government. I have decisions that I have to render every day for children and families. I may not sit in the normal court and see them, but I look at these files and I assess the decisions. I recognize that my agency, the Department of Family Services, they have a tough job. And sometimes we're human. They don't meet the mark either. And when they don't, and it doesn't pass up to the letter of the law, I am not ashamed to overturn that. But there are times where our department has done a tremendous job to help families, to keep the children safe, and to champion them. And I think that not enough people celebrate that.
Not all judges are bad in family court.
Correct.
But I just want to point out what's going on to make sure that the good judges don't fall into that trap.
Absolutely. Yeah. Absolutely. And if we can't handle sitting here with you two wonderful fellas, then we shouldn't be sitting on the bench.
Thank you.
I believe in what you stand for, because my husband is a living proof of your advocacy. And so I thank you and honor you for having me on here today. And we could do this all day. So
I know we could go another 2 hours and talk about family court. But Jim,
I promised my husband I'd get him a steak after this.
Good. Again, I have the same thing that Steve said. I really appreciate you coming on, and especially family court judges. And I don't typically do my rant that's basically about the subject line right in front, but that is something I'm really passionate about, because I lecture viewers and listeners all the time about educating themselves, understanding the process, because too many people get elected to these offices, whether it's family court, district court, president, vice president, all these offices. And then 2 years later, everybody wants to complain about them. I'm like, well, if you would have done your due diligence and actually understood what this person was about, prior, maybe we wouldn't be in this situation.
Absolutely.
So I want to thank you for coming on.
Thank
Marie,
you.
Marie Parladè.
Marie Parladè.
Parladè. I'd like you to look into the camera and tell folks why they should go to the voting booth and put you on the bench for Department A and your point of contact. And Mark's going to zoom in on you.
Thank you. Thank you for staying with us this past hour and 15 minutes. I know we've had very lively conversations, and I thank you, Steve, and I thank you, Jim, for having me. Thank you to all the veterans out there for all that you've done for our nation, for our families. I am Marie Parladè, and I will fight for what's right. I will fight for our families. I will fight for our children by applying the letter of the law, by upholding the United States Constitution, the Nevada Constitution, and the laws to ensure the best interests of our children and our families are met. I realize that there's challenges out there. I can't change the world, but you have my confidence. You have my commitment. I will focus on applying the law to the facts. You have my track record. For the past 20 years, I've been advocating for children and families. I've been fighting for children because they are I know it's cliche, but they are the future. They are the most vulnerable. I've sat as a judicial hearing master, as a jurist for almost 4 years in family court, for child abuse and neglect, for TPO, for delinquency, for drug court, for all the different courts. And I say that because it gave me perspective and understanding for the challenges inherent that our families face and the challenges inherent in our system. I'm not blind to the challenges in our system, but you have my assurance that I will apply the law to the facts and not allow any personal convictions, religious convictions, or any bias get in the way of what this family deserves. I've sat, and now I ask you for your confidence and for your vote, because I love our city, I love our state, I love our nation, and I'm not going to give up. Thank you.
Marie Parladè.
Parladè.
Thank you so much for coming on the program.
Thank you, Steve.
Thank you
Such an
for
honor.
answering our
Thank you.
questions. We really
Thank you.
appreciate it. We don't take this particular family court in Clark County lightly at all.
you.
We're very, very, very serious about family court.
I am too.
Extremely serious about family court. We have protest, we have court observed, and we have educated ourselves. And we're writing a book on family court, self-help book on family court. So litigants could know their rights and know
Yes.
how to represent themselves before a judge.
Absolutely.
So I just want you to know that. And thank you so much, Jim. Thank you. Folks, that's Marie Parladè, candidate
Parladè.
for Clark County District Court Family Division, Department A. We hope that you are educated and you look up this candidate. We're doing our endorsement interviews on August 3rd, beginning at 7 p.m. And we hope that all the candidates will come on the program for our endorsement interview and exercise their right for the public to know who they are. We have a strong viewership and people are really paying attention to this. This is Steve Sanson, Jim Jones for Veterans in Politics. Until next time.